what if the home is in a trust, but the contents or furnishings are not mentioned in the trust? All right, so a couple of things on this. One, the first thing that I always like to remind people, because this will often get forgotten, this has come up a lot even with my employees here in the office. In Florida, up to $20,000 in household tangible items such as furniture, appliances, things of this nature are exempt from creditor claims and don't have to go through probate. So if the house itself, if you can say the contents are not above that exemption amount, then those contents wouldn't be subject to probate anyway. But another thing we often do here and is sometimes overlooked is typically household furnishings are mentioned in the last will and testament if somebody does have an estate plan in place, or in an attachment that goes along with the last will and testament that's called a separate writing. So oftentimes what our office does is reference the trust in relation to either that section regarding household items or the separate writing, which is important, especially if there isn't going to be a probate, because then who really has control over the household items, which is probably what this comment may be getting at. You want to make sure that someone has control over it. So there's not actually going to be an executor, or how Florida calls it, a personal representative in charge of that. You want to make sure if there is a trust, that the trustee themselves would be the one in charge of those household furnishings. Again, as a final note, you could always mention that these items in the trust itself. I mean, there's nothing prohibiting you from doing that, especially if you have a particular reason where you want to mention that. They exist. Sometimes I have clients that are very particular about who they want these items to go to, as an example. So it's not wrong to include them if that's the case. But when you're doing a trust, you commonly also have what's called a pour-over will that goes along with the trust. The purpose of the pour-over will is to ensure that any assets, not mentioned in the trust do pour over into the trust. It lists the trust as a beneficiary. In this instance, though, even though the assets are pouring over into the trust, if it's an asset that would need to go through probate, like an account or something of that nature, it does still require a probate to get deposited into the trust. But where we're kind of a little bit more fortunate with household items and furniture and appliances is you do have this $20,000 limit exemption from probate. So in many cases, this can be utilized, to make it so that these items wouldn't have to go through probate. So I hope this answers the question. If not, you can send me something back that I can clarify on. And if you have any other questions about things that should or shouldn't be in a trust, any type of estate planning documents in general, anything to do with asset protection, Medicaid, and you're in Florida, please don't hesitate to reach out to our office. We're atCAUSE Law Office, the non-stuffy attorneys, and the link is in my bio.